B14-2 to please approach the lectern.
They'll never see the air waves.
My name's Paul PAAD, 2781 Cherokee Lane. I think I'm going to take a little different approach here than what you've been hearing so far. Mr. Chairman, a month ago, when this was brought back before the board, then Chairman McDowell said that tonight we would be discussing just this new evidence. This is what we're looking at tonight, is the new evidence. So that's what I want to try to concentrate on here. New evidence, as described by our county attorney. Part of it, I didn't get the exact wording, but part of it was basically it was something that could not be found by using due diligence. Is that, correct me if I'm wrong. I jotted down the five things that Mr. Tyler listed as new evidence. Number one was the concerns of the residents. Now, there was concerns 2 years ago when they were rezoning out there. Does it not seem like due diligence would have been going out and kind of checking with the residents before they put in the zoning application and try to resolve some of these issues in advance? He said the petition was new evidence. Had he done the due diligence of checking, seeing, testing the waters with the area property owners, I don't think that petition would have been a surprise. I've been told that they've even almost doubled the number of signatures on that since last week. 98 land use plan he offered as new evidence. This seems like that if you're going to develop an area, you might want to know what the land use plan was for that area. That's not new evidence, at least not in my opinion. History of the zoning in the area. Again, you have an experienced developer. This is due diligence gives you all of this. This does not fall under, in my opinion, does not fall under or meet the level of new evidence. The other thing he listed as new evidence was the benefits of this industrial park. Is he going to stand here and tell this Board of Commissioners that when he first presented before you, he had no idea what the benefits of this were going to be? That's not new evidence. He should have made that argument then. Okay, so I guess based on those 5 points of new evidence that he presented, I just honestly can't see what really is considered to be new evidence. Again, my opinion, but that's the decision that you as board members have to make. A couple of things I wanted to touch on. First of all, I'd like to thank Commissioner Winger for showing up at that neighborhood meeting. I thought it was at least showing a little interest in what was going on out there. Some of the things that come up during that meeting, talking about the enforcement of these covenants, and when the residents ask, well, gee, if you get a business in there that doesn't abide by them, who enforces it? He says, well, it's between the park and the owners. It's up to those owners to go get an attorney or come to you. That's what he said, or basically try to enforce them through a court of law. So putting a burden, if somebody decides not to abide by the covenants, on these residents to have to hire an attorney and pay for it and go through court and do all that. So at that meeting, Mr. Tyler indicated that there was some interest in the industrial park already, and he had received some interest. At least twice, he was asked what types of businesses had shown interest in there already. He skirted it, would not answer, he would not give it. He mentioned a couple here tonight, but at that neighborhood meeting he wouldn't mention. Nobody asked him what businesses, just what types. He also mentioned when they were discussing concerns about the traffic on Salt Creek, he just jumped around and said, well, there's going to be a turn lane out there. That's the first I had heard of that. Maybe it's buried somewhere that I don't know. I guess my question is, who's going to pay for that turn lane? Is it in planning somewhere? Is that part of the permit? I hadn't heard of that before. Okay, if you go to what Mr. Tyler offered as covenants and such, if you look at it, he offered covenants on lots 6, 7, and 8. Lots 1, 2, 3, 4, and 5 had no restrictions placed on it under his covenants.
Yep.
That's, I understand the lots he was using are the ones that border directly next to it, but that's not that wide a piece of property. If you're putting in asphalt plants, or you're putting in somebody that might have storage facilities, he limited the fuel or flammable storage facilities down to 12,000 gallons per lot on those 3 lots up there. There's no limit on it on the other ones. What my next concern with that would be, you have one access coming in there. If you have anything to do with chemicals in there, if you have any kind of flammables, fuel storage, gasoline storage, and we have a catastrophe up there where we have a fire, the fire department's got one way to get in there. Now, the prevailing winds are such that they can't come in that driveway, that access. It's going to be hazardous to our firefighters. They already have a bad enough job. Tough, as I mentioned, in less than a week, it seems that they've almost doubled the signatures on the petition. Now I'm going to come to my point of contention on this whole thing. My major point, I guess, is that, as I mentioned earlier, I don't believe we should even be voting on whether or not to approve this zoning change. And if you will, I have copies of the Chapter 10, or do you have them in front of you?
No, they don't.
Thank you.
I know we're only talking about one section of this, but I printed out the entire chapter because I didn't want anyone thinking something was taken out of context. What if we go to 10.1p, which is on the third page, which is page 206 of the regulations on the bottom. It's very short, very narrow in scope. It says, no application for a zone change which has been denied wholly or in part by the board may be resubmitted for a period of 12 months from the date of said denial, except on the grounds of new evidence or proof of change of conditions. I think we can all agree that I don't think conditions have changed out there. So we have to do this on the grounds of new evidence. And what this is specifically referring to is that if there's new evidence, you would be able to waive the 12-month waiting period prior to resubmission. This is the specific regulation that this was brought before the board under, and it would be my contention that that's what you should be voting on tonight, is whether or not to allow this to be resubmitted prior to the 12-month waiting period as required under the regulations. I'm sorry, I lost my place here. Okay. Anyway, that kind of pretty much summarizes what I'm at, but I just, since it was brought back to the board, or back before the board, specifically under this section of the regulations, I believe that's the section that you should be following with. I guess the only other thing I'd have, I find it kind of ironic, don't know, maybe it's just me, but I find a little irony in the fact that Mr. Tyler's seeking zoning change from urban mixed residential to light industrial in order to build an industrial park that abuts up against a residential area on these 29 acres. While at the same time, over on Robertson Road, he's asking for exactly the opposite, a light industrial change, zoning change on 31 acres from light industrial to urban mixed residential so he can build or develop residences right up against the existing commercial area. So I just find the irony in that. So, but again, I really think that we should be considering just what we're voting on here tonight, or what you are voting on. That's all I have. Thank you.
Any questions? Thank you, Pat.